Here we go. Whisper.
Korea's biggest law firm, Kim Chang, just walked out of a $29 million lawsuit 3 weeks before opening arguments. All 5 attorneys gone. The case, ADOR versus Danielle Marsh and Min Hee-jin. Korean legal observers are calling this highly unusual. The reason, not disclosed. So what did Kim and Chang see? This isn't just a lawyer's web story. It's the most expensive single-member damages claim in Kpop history, and the law firm running it just disappeared 3 weeks before trial. Let me lay out the timeline. December 2025. ADOR filed a 43 billion won lawsuit, about 29 million US dollars, against Danielle Marsh, her mother, and former CEO Min Hee-jin. ADOR's claim, Danielle's hiatus delayed all 5 NewJeans members from working, and that's how much the company says it lost. At nearly the same moment, ADOR terminated Danielle's contract. 4 members, Hai and Heron and Honey, returned to the agency. Danielle alone was cut off. Then in January 2026, ADOR escalated. They filed for a property freeze on Danielle's mother and Min Hee-jin's. On February 2nd, the Seoul Central District Court approved 2 billion won from Danielle's mother, 5 billion won from Min Hee-jin, combined 7 billion won, roughly $4.7 million in real estate loss. A property freeze means the court agreed there's a legitimate risk of asset flight before trial. In other words, ADOR isn't just bluffing. They've convinced the judge they intend to collect. That's the picture from December to February. Then March came and the mood shifted. On March 26, 2026, the first preparatory hearing began at Seoul Central District Court. A preparatory hearing is where both sides organize the issues and evidence before the actual trial. The 2 sides went in opposite directions. Danielle's team asked for a fast schedule. ADOR pushed for more review time. Why? For Danielle, every month of forced inactivity is more career damage. For ADOR, the longer the case drags, the longer Danielle stays out of the market. According to the Korea Times, the court resolved the timing dispute by setting 2 hearings. First arguments on May 14th, second on July 2nd, 2 rounds to fight out the core issues. Up to here, this is a normal civil dispute, big numbers, famous names, but the procedure was on track. The next thing that happened was not April 24th, 2026. Exactly 3 weeks before the first hearing, all 5 of ADOR's attorneys filed to withdraw. The firm? Kim and Chang Law Firm. Let me explain why the name Kim and Chang matters in Korea. Kim and Chang Law Firm was founded in 1973. Over 1,000 attorneys. They handle more than half of Korea's largest legal cases. Samsung, Hyundai, SK. They're the firm Korean corporations core. They're also who the Korean government uses for international disputes against foreign governments. Firms of this size very rarely walk out mid-case. Once they take a brief, they finish it. The exceptions are narrow. Client doesn't pay, client lied to the firm, a late discovered conflict of interest, or something else extraordinary. But Kim and Chang walked out, all 5 attorneys, 3 weeks before opening arguments. The Korea Times, Kpop, Mail Business, and Sport TV News reported it the same week. The Korean legal community gave near identical statements. A major firm withdrawing right before opening arguments is highly unusual. But here's what we have to be clear about. Why Kim and Chang withdrew has not been disclosed. Outside speculation is possible. The only definite fact is the timing, highly unusual timing. And of course, this triggered speculation. There's one theory that's been pushed hard in the Korean conversation. On multiple Korean outlets and K-pop communities, the framing is this. Strategic stalling. The logic goes like this. From ADOR's perspective, the longer Danielle is forced to sit out, the more her market value erodes. Even if she ultimately wins the case, the lost time accumulates as her loss, not theirs. And when counsel suddenly withdraws, new counsel has to start from scratch and ask the court for more time. But here is a critical fact. According to Krew, the court rejected further delays and instructed the case to proceed quickly. In other words, the court signaled that ADOR cannot run the clock if the clock is what they wanted. New counsel is going to have to walk into May 14th without a lot of preparation. Let me say this clearly. Strategic stalling is a theory. There's no evidence ADOR coordinated with Kim and Chang to engineer withdrawal. Kim and Chang may have decided independently. There may be reasons we simply don't know, but on outcomes alone, the pressure on Danielle just increased. If you step back and look at where ADOR actually sits today, the picture gets clearer. ADOR was founded in April 2022 as a joint venture between HYBE and Min Hee-jin. HYBE owns 80%. The company is based in Yongsan, Seoul. NewJeans debuted that July. With one group, ADOR moved chart records. Then the dispute between Min Hee-jin and HYBE Corporate started in April 2024 and changed everything. By August, she was removed as CEO. By November, she had resigned from every remaining title. Around the same time, the 5 NewJeans members publicly demanded her return and found themselves in conflict with the agency. A year later, December 2025, ADOR sued Danielle and Min Hee-jin. Out of the original 5 members, only Danielle was placed across from the company, a 4+1 structure. Today, 3 members work inside ADOR. Hein, Heroin, Honey, Danielle is removed, and against that one removed member, ADOR is asking for 43 billion won in damages. This is the situation. A company suing one of its own group members for the largest single-member Kpop damages claim Korea has ever seen. So what happens on May 14th? This is shaping up to be the inflection point of the case. There are roughly 3 scenarios. 1. HYBE moves fast. New counsel is appointed, gets the file, and walks into court underprepared. Quality of advocacy drops. Atmosphere tilts toward Danielle. 2. ADOR reads the room and pivots to settlement. With the property freeze already in place, they negotiate from a position of leverage, get partial cover for the original claim, and Danielle gets to come back. 3. The hearing simply proceeds and the contours of a first ruling start to emerge. Whichever side the court favors, this becomes the new baseline for how Korean courts read a member versus agency contract dispute. I don't read this case as a single member story. I read it as a signal. A signal about how K-pop contract structures hold up when an agency and its artists actually go to court. On May 14th, who walks in? What card they hold? That single moment will shape the next chapter of this long case. I'll see you when that day comes.
Crew chosen. Crew chosen. Yeah.